Hey everyone, and welcome to This Explainer. Today we're going to unpack a pretty fascinating 2004 Constitutional Court ruling out of South Africa. And what's really cool about this case is that it turns what looks like a super dry procedural dismissal into an absolute masterclass on legal strategy. We are looking at the case of Western Areas Limited versus the state. Now on the surface, sure, it's about a legal filing, but dig a little deeper and it's actually a story of high-stakes anxiety, over-engineering a defense, and a court that had absolutely no patience for it. Let's dive in.
So let me ask you something right out of the gate. Can you appeal decision before it's even been made? I mean, logically, that sounds completely absurd, right? How in the world can you challenge a ruling that literally doesn't exist yet? But as you probably know, in the high-pressure world of criminal litigation, when the walls are closing in, lawyers will sometimes try to bend the very fabric of time and procedure just to protect their clients. And this seemingly illogical question is the exact legal conundrum at the heart of our explainer today.
All right, let's kick things off with Section 1, the fraud charges, and the high-stakes anxiety behind them.
To set the stage for you, we have three main players here: Western Areas Limited, Roger Brett Kebble, and Roger Ansley Ralph Kebble. And the stakes for these guys? They literally could not be higher. They were facing various, extremely serious counts of fraud in the High Court. Naturally, their legal team decided to go on the offensive early. They filed an objection to the indictment under Section 319 of the Criminal Procedure Act 5-1 of 1977. Basically, they were trying to get the charges thrown out on a legal basis right then and there. But the court wasn't having it. Their objection was dismissed. So they lost round one.
Now, what's really interesting here is the sheer panic of their legal response. Instead of just taking the loss and preparing to fight the actual trial, they turned the case into this crazy, multi-layered legal battlefield. So, in the High Court, the fraud charges are still pending because their objection failed, right? Well, at the exact same time, they filed an application for leave to appeal that dismissal to the Supreme Court of Appeal, or the SCA. But they didn't even stop there. They simultaneously ran straight to the highest court in the land, the Constitutional Court, and filed a conditional leave to appeal. You guys, they were fighting in three different courts all at once.
Moving right along to Section 2, a conditional appeal, which was a pretty unorthodox maneuver.
Okay, so everything the applicants did from this point forward was driven by one powerful emotion: fear. Their legal team was terrified. Sure, they had filed an appeal with the Supreme Court of Appeal, but they were deeply, deeply worried that the SCA wouldn't even look at the actual substance, the merits of their appeal. Why? Because of past legal precedents. The applicants anticipated that the SCA might just refuse to exercise jurisdiction entirely, and they specifically pointed to past decisions like S.V. Basson and R.V. Adams. Basically, they were terrified of getting thrown out on a procedural technicality without ever getting a fair shake.
And that intense fear is exactly what birthed this whole concept. A conditional leave to appeal is basically an application that just sits dormant. The applicants weren't asking the Constitutional Court to hear their case right that second. They were essentially saying, hey, we're just going to leave this paperwork here with you. Please only activate it if the Supreme Court of Appeal refuses to consider our case on its merits. Notice they weren't conditioning it on the SCA refusing the appeal entirely. They were conditioning it specifically on the SCA refusing to consider the appeal on its actual merits. They were trying to buy a procedural insurance policy.
Which brings us to arguably the most pivotal question of this entire explainer. Did they actually need this safety net? Was this highly complex, preemptive strike really necessary to protect their constitutional rights?
Well, the Constitutional Court answered that question with a sledgehammer. 9 Constitutional Court justices, we're talking heavy hitters here, including Chief Justice Chaskelson and Justices Madala, Mogoro, and Sachs, unanimously declared the application is misconceived and unnecessary. Ouch. I mean, in legal speak, that is the equivalent of a door being slammed squarely in your face. It's basically a very polite judicial way of saying you have completely misunderstood how this court works, and frankly, you're wasting our time.
So why the harsh smackdown? Let's look at Section 3, the constitutional rules, the actual rulebook.
The judges didn't just dismiss the applicants out of pure annoyance. They relied strictly on the text itself, specifically Rules 19.1 and 19.2 of the Constitutional Court. These rules are the ultimate blueprint for how and when any aggrieved litigant can bring an appeal from another court, like the Supreme Court of Appeal, all the way up to the Constitutional Court.
And honestly, when you break them down, those rules are beautifully simple. Instead of inventing elaborate conditional safety nets, Rule 19 just lays out 2 extremely straightforward steps. Step 1, you just wait for a court, like the SCA, or even the president of the SCA, to actually make a decision or refuse your leave to appeal. Just wait. Step 2, once that order is officially given, the aggrieved litigant simply has a guaranteed 15-day window from the date of that order to lodge an application with the Constitutional Court's registrar. That's it. The safety net isn't something you have to magically invent, it's literally baked into the timeline.
So you can see how this really comes down to a massive clash in logic. You have the applicant's strategy, which was driven by pure, unadulterated panic: file immediately, clog up the court system with a hypothetical scenario just in case something goes wrong at the SCA down the line. Contrast that with the calm, structural logic of the rule-based timeline. Just wait to see what actually happens. If the SCA refuses to hear your merits, you aren't out of luck. You simply use your standard 15-day window to file a normal appeal. It's that simple.
Which brings us to the end of the line, Section 4. The final verdict. Spoiler alert, it's a clean dismissal.
The Constitutional Court laid out their logic absolutely flawlessly here. They reminded Western Areas Limited and the Kebbles that it is entirely competent, meaning legally valid, for them to apply for leave to appeal within 15 days of a decision by the SCA refusing to consider the merits. Furthermore, it is also perfectly competent to apply within 15 days if the president of the SCA refuses leave. Therefore, there is zero risk of them falling through the cracks. The rules of the court already provide literally all the protection they were begging for.
And because the rules already had their back, the court delivered the final blow. The application for conditional leave to appeal must be refused. The application is dismissed. No caveats, no exceptions, just a clean, unanimous dismissal of a legal strategy that tried to outsmart a system that was actually already designed to be fair.
So I want to leave you with this final thought to ponder. When you are navigating complex systems, is inventing your own procedural safety net ever a good idea when the rules already provide one? The Kebbles and Western Areas Limited paid top-tier lawyers to build this crazy, hypothetical legal parachute, completely ignoring the fact that the Constitutional Court had already handed them a perfectly good one. It's just a really powerful reminder that sometimes the absolute best strategy isn't the most complex maneuver. It's simply reading, understanding, and actually trusting the rules as they are written. Thanks for hanging out with me for this explainer, and definitely keep questioning the systems around you.